A very good afternoon, everyone. I seek the permission of the chairman, Dr. Omprakash, to commence the session. Can we start the session, sir?
Yes, can.
Thank you. A very good afternoon once again to all of you. Thank you very much for your kind participation at this exclusive session, and we welcome you all. The session on competition law and data protection, redefining the narrative, is organized under the aegis of Corporate Economic Affairs and Legal, including BIMACC Expert Committee. On behalf of the Chamber, we express our sincere thanks to Messrs. Lakshmi Kumaran and Sridharan, attorneys, for giving us an opportunity to jointly organize this session. The Chamber welcomes today's speakers, who are the partners of Lakshmi Kumaran and Sridharan, Ms. Charanya Lakshmi Kumaran, Mr. Prashant Phillips, and Ms. Neelambara Sandeepan. Welcome you all for this session. The Chamber, the Corporate Economic Affairs and Legal Expert Committee is led by Dr. K.V. Omprakash, who is the Advocate and Founder Director, Head Legal of Conscientia Consultancy, co-chaired by Mr. Ramprasad, Practice Head ASA and Associates, and mentored by Mr. Venkatakrishnan, former advisor, Tata Hitachi Construction Machinery Company. We also express our sincere thanks to Mr. Murli, who is the advisor of BCIC and Vice President of Toyota Susho India, for facilitating this session. Thank you, sir. And thank you very much once again to all of you. And now I would request Dr. Om Prakash to set the context. Before I hand over the stage to him, the Chamber acknowledges our member organizations for their annual support for our events by way of sponsorship. Mrs. Bueller, Fundermax, MTR Foods, IAMPL, SDMIMD, Sona Group, TVS Motor Company, Vishwas Group, and Wipro. Thank you once again, and over to you, Dr. Om Prakash.
Thanks, Rupa, for the welcome address, and good evening, all. It's a wonderful evening, and I thank everybody, those who have taken time to and yet another webinar on this very important topic, which is talk of the town now. And I would welcome all the members who have joined this webinar. And I also thank Mr. A. Murali for curating this entire event. And I thank and welcome the speakers of the day, Charanya Lakshmi Kumaran, Prashant Phillips, Neelambara Sandeepan. So the topics which is today being taken is the competition law and data protection. Though they are different topics, but they have connections in between. The whole webinar will be in two sessions. The first session being the competition law rule book for digital markets, the road ahead. So this session will be dealing with the Competition Commission India's recent judgments penalizing various digital tech companies for antitrust violation. Now, what are the judgments? How far it is impacting us? How is it going to be addressed by the companies? How is it that CCI is going to look into it, and how are they going to react? So these are the various topics which will be covered in this session by the speakers. And there are some amendments also which are proposed. Those things also will be discussed in this session. The next section will be on Digital Personal Data Protection Bill 2022, and it is in a question format. Does it provide a free and trade digital marketing, digital economy rather? So now e-commerce is the talk of the town, and they are the frontliners. Everybody is looking at e-commerce. What are the various protection under that? How is data getting protected? The framework for data privacy in India. So these are the topics which will be discussed, and also the proposed bill, which is going to replace the Information Technology Act, and which was published recently by Ministry of Electronics and Information Technology. So these are the various topics will be discussed. Under this topic, does it provide a free, fair digital economy? The Digital Personal Data Protection Bill 2022. So with this, I would not take more time. I would pass on the topic for discussion and detailing by the speakers of the day. And Rupa, I would like you to invite Murali to introduce the speakers.
Yeah. Thank you very much, sir. I would now request Mr. Murali to introduce our today's session speakers. Over to you, sir.
Thank you, Rupa. Thank you, Dr. Om. Good afternoon, viewers. We have three eminent speakers from Lakshmi Kumaran and Sridharan. We are very fortunate to have them today. First on the list is Ms. Charanya Lakshmi Kumaran. Charanya Lakshmi Kumaran has more than a decade of experience in tax and several years of experience in competition law, insolvency and bankruptcy law, IPR and electricity laws. She currently handles tax as well as non-tax litigations at the High Court and Supreme Court, as well as other tribunals and regulatory forums. Second on the list is Ms. Nilambara Sandeepan, who is again a partner in Lakshmi Kumaran and Sridharan. And she has over 11 years of experience. She has extensive working experience advising Indian and foreign companies in relation to the full spectrum of competition issues, both advisory and proceeding before the Competition Commission of India, National Company Law Appellate Tribunal, the High Courts, and the Supreme Court of India. And we have also with us Mr. Prashant Philip, who is again a partner, who's got extensive knowledge in the design, patent prosecution, and patent litigation and related support practices at L&S. He has expertise in inventions related to software, telecommunication, electronics, and electrical engineering, and wind energy. Prashant advises clients on cyber laws with focus on data protection and data privacy. His experience also includes patent preparation, patent prosecution, patent litigation, and industrial design practice at Lakshmi Kumaran and Sridharan. He appears regularly for hearings before the Indian Patent Office for both patent and design matters. This is a brief introduction of all the three speakers, and I now invite the speakers to take over the session. Over to you, Rupa. Thank you.
Thank you, sir. Now, may I request Ms. Charanya Lakshmi Kumaran to take over from here. Over to you, Ms. Charanya.
Hello. Good evening, everyone. I have to thank the chamber. I have to thank Mr. Murali and everybody here. I'm sorry, I'm panting a little. We just got back from the High Court somehow just in time today. So, as very rightly pointed out, this is a very important, relevant topic that we are going to be discussing today. The Competition Commission of India over the last 10-12 years has passed various orders time and again. It acts as a regulator of markets and tries to ensure free and fair market practices to be prevalent in India. Initially, everyone talks about competition law, and that largely they'll be looking at cartels, abuse of dominance, monopolistic behavior. But over the last few years, their attention has been taken to the digital space. And so today what we're going to discuss is a little bit about the recent judgments that they have passed. I'm sure many of you are interested for academic purposes. That is why we have such a lovely turnout today, because everybody wants to know what really was held in these orders. Secondly, we are also going to explain, if you are not a digital company, you are a regular offline brick and mortar company, you may have some digital presence or not. But what can be the impact of the trend that the Competition Commission is following over the last few years? So please don't feel bad that you're not a digital company. Don't think it is not relevant. Everything somewhere always ties up. And we will be explaining to you how these issues are relevant towards the end. The second session, what I will do is I'm now going to hand over to Nilambra. She will take us through this presentation. I will join her when we are going to do the takeaways from the recent orders, the impact it can have on industry. And then I will, when we start the next session, I'll set the context and assist Prashant also like that. So over to you, Nilambra.
Good afternoon, everyone. It's a pleasure being here amongst all of you, and thank you, everyone, for joining us for this session. Sharanya correctly pointed out about, what is the relevance of it, and, given that it's a very specific topic that we are going to be addressing today, let me just, take a step back and, talk a little about competition law in general. So competition law is a sector agnostic legislation. So whether you're a digital company, you're an offline company, the principles of competition law stay constant and stay the same. And this is why when competition law started impacting digital companies, they were quite taken aback because they felt that, we are not a large manufacturing company. We don't have, large distribution channels. For a lot of them, they're only marketplaces. So, they just connect buyers and sellers. So, it's not like that even offering any services or any goods to consumers directly. And then why is it that, they should be considered as part of the market, and, how does their conduct affect competition in the market? So these are some of the issues that, have been addressed by the CCI in the last set of orders that we'll be discussing today. And this is not something that has happened over time. It is not that the CCI has, suddenly started looking at these issues from a digital markets perspective. These issues have been raised time and again. And over a large period of time, honestly speaking, if you have to just set the context, competition law in India itself has only been around since 2009. And so therefore, the time period that the competition law has been in force in the country itself is a very short period. But even in that period, for the past 7-8 years, issues from digital markets have been raised. The CCI has looked at them, and it is after all of these years of scrutiny that finally we have these orders. Now, like I said earlier, that competition law is sector agnostic. So whatever principles, whatever issues that we raise in terms of the conduct which the CCI is frowning upon, all of these apply equally for companies which are in the offline space. So be it a cartel, be it abusive dominance, be it anti-competitive vertical restraints. All of these issues are the same for offline companies as well. But the markets that they operate in is what will determine how they are positioned and whether their conduct is anti-competitive or not. So with this, I'm going to start with my presentation, which is the topic for the day, that is Competition Law Rulebook for Digital Markets. And I would be happy to take questions during the presentation. If you want, I can just take pauses after every section, or if it better suits everyone, then we can do them at the end. So I'm flexible in terms of that. So before we start, dwelling into what is it that is problematic from a competition law perspective for digital markets companies, I thought it'd be nice to just set the tone in terms of what is considered digital market. Now, officially or legally speaking, there is no definition of what constitutes the digital market, but any business which uses digital inputs, includes digital technologies, digital infrastructure, digital services, data, is considered to be operating in the digital markets. Okay, of course, the extent of it will differ. Some companies will have more, some less, and All of that will determine which market is the CCI going to look at a company when they are analyzing its conduct. Now, in digital markets, very interestingly, there can be companies which are single-sided markets. So let's say there is a website of a brand, for instance, Nike. Nike has its own websites. It sells directly to its customers. Now, that is a single-sided market. Nike only caters to one set of individuals, which is its direct customers. Whereas something like Amazon or Flipkart or Swiggy, Zomato, Uber, all of these companies are marketplaces, or they are two-sided markets. So Amazon is in the middle. On one side, it has the sellers who list their products on Amazon. On the other side of the platform are customers like you and I, who are interested in purchasing these retail products. And what Amazon does is that it just creates an interface which allows the sellers to be connected to the buyers. Now, that is a two-sided market. So for Amazon's perspective, there are two sets of customers. One is the sellers and the other is the buyers. And its job is not to provide any goods. Its job is to only connect the two sets of players in the market. Now, in competition law, there is a very interesting concept, which is that of the relevant market. Now, why is this important? It is important because the conduct of any enterprise has to be seen from a competition standpoint in the context of the relevant market in which it operates. Now, the relevant market is nothing but a combination of the relevant product market. So all the products which constitute the market. So let's say if there is a shoe manufacturer, who are its competitors? What are the products which are considered to be substitutes of this shoe that this particular manufacturer is selling? Then there is a relevant geographical market. So not all goods or services are capable, or not all enterprises operate on a all India level. Some would be regional enterprises, some would be national enterprise. So depending, and some goods will be very local, some would be available across the territory of India. So depending on the market in which the conditions of competition are homogeneous, the relevant geographical market is defined. So a combination of the relevant product, so all the substitutable products, plus the geography in which the conditions of competition from the perspective of the consumers as well as the service provider or the manufacturer or distributor are homogeneous, the relevant market is defined. Now, this relevant market is the bottom line, and every competition investigation revolves around it. So, very similar to what is this concept in the physical space, even in the digital markets, this concept had to be defined to be able to assess whether a particular enterprise is in violation of competition law or not. Now, before we move on, I'd like to give an example, and this is one of those examples which sets this concept and explains it very, granularly. So, for instance, if today I, as a purchaser, I want to buy a residential apartment in a high-rise building. Now, and I want to buy it in Gurgaon, which is a suburb. Now, if I want to look at only high-rise building apartments in Gurgaon, I will not consider other parts of NCR substitutable in terms of the geography. So I will not want to look at Delhi. I would not want to look at Noida, Faridabad, Ghaziabad, all of these other areas which are part of the NCR region. They're not substitutable because I want to live there. Maybe, my workplace is there. Maybe my kids go to school there, or maybe my family lives there, or just out of personal choice, I just want to live in Gurgaon. I don't want to live in any, or I think the infrastructure is better there, accessibility is better there. So there could be a lot of reasons why I have chosen that as the area in which I want to live. On the other hand, in terms of the different kinds of residential spaces that I can choose, I don't want to live in a bungalow. I don't want to live in a farmhouse. I don't want to live in a standalone house. I want to live only in high-rise apartments. So none of these other kinds of residential properties are a substitute in terms of the product for the requirement that I have. So basically, then the relevant market for my purposes is high-rise apartment building complexes in Gurgaon. I hope that clarifies the concept of the relevant market. So now when the CCI started looking at digital markets companies, the first challenge it had was definition of the relevant market. Now, way back in 2014 is when one of these first cases came before the CCI, and this was an information filed against Snapdeal, which is one of the e-commerce players. Now, at that time, CCI said that, listen, your e-commerce websites, they are able to service the entire geography of India. So in terms of the territory, there's no issue. But is it a different relevant market altogether? Or is it just another channel of distribution for the same products which are being sold in the offline market? So if the products, at that time they said that if the products are being sourced from the offline market are the same as that which are being sourced from the online market, and if the consumers consider these two channels as substitutes, then they are not really different markets. They're just different channels of distribution for the same larger retail market in the country. Now, this position changed very quickly when in 2018, now this is, and in between there were a lot of other informations that were filed for digital markets companies. And this was an information, and this was the second sort of information which was filed against Flipkart. Now, in this case, the CCI said, while earlier we have said that there are different channels of distribution, online and offline markets, but now we feel that the features, the convenience, the time saving, the cost saving that the online marketplaces offer to both the sellers, because now the sellers don't have to keep their inventory. Amazon or Flipkart have their warehouses where they can stock it. The customer doesn't have to leave his house and go to 5 different shops before he makes a purchase. He can just do it with a click of a few buttons on his phone. So all of these factors are very different from when somebody is selling and buying in the offline retail space, and therefore these are not different channels. These are actually different markets where the dynamics are completely different. This was the first time that the CCI said that the online and offline markets are two different relevant markets altogether. 4 years later, which is last year in 2022, when one of the first few sets of orders for digital market companies, especially in the e-commerce space, were pronounced by the CCI. And this time the CCI looked at an even smaller market as the relevant market. So this was in the case of MMT Go. So MMT, as we all know, is a website where you can book hotel tickets, you can book flights, buses, etc. So in this case, the CCI said that, of course, the online and the offline channels are different. So, there's no question of substitutability there. And we feel that even in the online channel, all the different modes to which somebody can book a hotel ticket, a hotel room, are not substitutable. And they said that because they felt that what MMT was offering as a service was very different from, let's say, what the hotel's own website could offer. So they said that MMT was offering something called the search, compare, and book feature, which was not available for, let's say, a hotel like Taj Hotel, if they were selling rooms on their own website. So that online market, which was constituting the hotel's own website or general search or other websites like Trivago, where you can get listings, you can compare features, but then you're redirected to another website to book. Now these were not part of the same market as Make My Trip. Make My Trip's market was that of online intermediation services for hotel bookings, and in this market MMT was found to be dominant. So as you can see, in any competition investigation, it is always the regulators' eye here to narrow down the market as much as possible, because the narrower the market definition, the more likely is that a particular enterprise will have some conduct which would be anti-competitive. Whereas as a company, you would want to broaden your market as much as possible when you're defending yourself, so that you are not considered to be dominant or to have significant market power in a particular market. Now, this is something which usually conflicts with, when one is preparing investor pitches, when one is reporting its company's performance and all of that, because you want to you want to portray yourself to be in a very niche space, and the more niche you portray yourself to be, the smaller the market is going to be. So there's a potential conflict here about how companies should go about creating their image, because it could lead to a conflict if there is ever a competition investigation. So now I'll quickly move on to the cases here. So October 2022 was a very interesting. A series of cases were decided, and CCI passed orders in 3 cases back to back in the digital market space. 2 of them were against Google, and 1, of course, MMT Go. And the penalties rather which were imposed were also quite significant, and also showed how the CCI was thinking about these companies and penalizing them. So first, talking about MMT Go. So MMT, as we all know, is this platform. Now, MMT had entered into an agreement with OYO, which is a hotel franchise. Now, MMT Go and OYO had an agreement, which basically said that MMT Go would not list on its platform any of OYO's competitors. So other hotel franchising companies like Tribo, Fab Hotels. Now, pursuant to this agreement, Tribo and Fab Hotels were actually delisted from the MMT platform. And along with FRHAI, these were the 2 companies who had filed the information against MMT and OYO. Now, they said that this is anti-competitive because MMT is in a position of dominance in the market for online intermediation services for booking of hotels. And this conduct by MMT is anti-competitive. In addition, the vertical agreement that is there between MMT and OYO is also anti-competitive because it is denying market access to competitors. And it is an exclusive dealing agreement between OYO and MMT. Now, in addition to this agreement, MMT was also investigated for some of the conditions or some of the clauses in its agreements with other hotel listers. And these were considered to be unfair conditions, such as predatory pricing, imposing room parity or rate parity. So basically, if a particular hotel had only 1 room night available for a particular day, if they were showing it on their own website, they also had to show it on MMT's website. Similarly, if a particular hotel was listing the lowest room rate on its own website, then that same room rate had to be offered to MMT also. So its own website or any third-party website also, if they were doing, they had to offer basically the best rates to MMT. Then, in addition to all of these restrictive clauses, MMT was also seen to be doing something called deep discounts. So they were offering discounts out of pocket. And there were also allegations of misrepresentation, which later on turned out to be a technical issue, which was that while Tribo and Fab Hotels were delisted officially from the MMT platform, instead of not showing, so let's say if somebody searched for a Tribo or a Fab Hotel, it is not that those would not appear in the search or the search results would say no results found, but instead those hotels were shown sold out, which it was alleged had a negative impact on the business of these hotels. Now, while conducting this entire investigation, the the CCI, of course, had already defined the relevant market, and which was investigated by the DG investigation. And the CCI, at the end of receiving the report from the DG investigation, agreed with the findings and said, yes, the market is the market for online intermediation services for booking of hotels, because these are services whose characteristics are very different from any of the other online modes of booking hotels. Now, interestingly, when the CCI made this assessment, they only looked at the perspective of the lister, that is the hotels. They did not conduct any consumer survey to say whether the consumers consider MMT to be to have any substitute. So typically, when, let's say, one of us is booking a hotel, there are different modes through which we can book a hotel, and a lot of times there is sensitivity towards price, sensitivity towards availability, or the preferred room category. And it is not that we are always, you would just always go to MMT and book, or you would only use one channel while booking. So it's quite common that the consumer would probably look at the price on MMT, probably go to the hotel's own website, pick up the phone and ask for offline rates, and then make a concerted and a considered decision. But the CCI didn't see it that way. They said that when you're looking at conduct which is anti-competitive from the perspective of the lister or the service provider or the seller, then we are going to consider their perspective and to see how they are impacted, how they behave. So they only looked at how the hotels perceive MMT as a trading partner. And they said that for anybody who wants to sell hotels online, MMT is a non-negotiable trading partner. Now, MMT was, of course, found to be dominant in this market because of their high market share, the large number of hotel listings, and something called the network effects and dependence of hotels. Now, this network effects is a very interesting concept, and this is something that most digital market companies are very familiar with. And while conducting competition assessments for digital market companies, this is a concept that is always looked at. Now, network effects is nothing but the effect of one particular offering or service or product on other offerings or services or products of a company. So, in a simple example, MMT is in a position of market power or dominance because of the number of hotels who are listed on there. Now, hotel wants to list itself on MMT because of the customers it drives. Now, customers want to go to MMT because the largest numbers of hotels are probably listed on MMT. So it's a cyclical loop where one feeds off the other, and because of the network that is built of the hotels and the customers, the platform becomes a platform of value to both the sellers and the purchasers. Similarly, something like a WhatsApp. Why is WhatsApp so popular? Because if today I had to move to Telegram, I can move to Telegram, but I wouldn't have, let's say, my entire family, my colleagues, my friends on Telegram. And if there is nobody that I can speak to on Telegram, then Telegram is of no value to me. But because more people are on or are using WhatsApp, even more people are inclined to use that particular platform for communication. So that is what network effect. Now, in the context of MMT, the CCI said that there is network effect because they're not operating just hotel bookings platform. They are also offering other services. They are selling airline tickets. They are selling insurance. There are also bus tickets that you can book through MMT. And when, let's say, somebody comes to book a flight ticket, you have that person's data, you know where this person is going, and you suggest, possibly a hotel to him as well. And then this person is probably likely to buy the hotel also from MMT because, it's convenient. And so therefore, this network that is created of all the listings and all the customers plays a big part in how MMT functions. They also said that because of the popularity, because of the high number of listings and the network effect, MMT is an important gateway for hotels to reach end customers. And therefore, hotels have no choice but to accept the conditions that were imposed by MMT. So these room parity conditions, the extra discounts that it can offer, the price parity, and all of these are conditions which, because any new entrant in the market would not be able to get these conditions out of the hotels, will always be at a disadvantage, and MMT will not have any competition. The CCA also said that because first of all, you have all of these parity clauses, and then because of MMT's own financial standing, they're able to offer big discounts on the hotel rooms over and above what the hotels are offering. And because of this, the cheapest rates will always be available on MMT, and therefore the largest number of customers will always buy from MMT, even if there are other modes through which they could book hotels. So based on all of these factors, the CCI held MMT to be in violation of competition law, and they were imposed with a penalty of 223 crores. Now, OYO was also found to be engaging in anti-competitive behavior because it was in an agreement with MMT to restrict market access for other competitors of its own. And for this, OYO was also imposed with a penalty. Now, the interesting thing is that while the relevant market that was defined for this case was just that of online intermediation services for hotel bookings, this penalty amount that is there was calculated on the total turnover of MMT, which includes the hotels, the flights, the buses, the insurance, and all the other lines of business that it is engaged in. While none of those lines of business were found to be anti-competitive. So this is very interesting because in the past, the Supreme Court has issued directions saying that if you find a particular enterprise to be in violation of competition law, while imposing penalty, you have to look at the relevant product, which was where the anti-competitive conduct had happened. And you can't impose penalty on the total turnover because that is not affected, because a company can have different lines of business. And if something has not benefited or something has not been impacted by the anti-competitive actions of a company, then that turnover, that revenue has to be kept out of the purview of the penalty. Well, this was not followed in this case, and the CCI said that because of the network effect, the different lines of business feed into each other, and therefore everybody and all the different lines of businesses have benefited from this anti-competitive conduct. So this is what happened in the MMT case. Now, if there are any questions, I can take those, or I can move on to Google.
As of now, there are no questions in the chat box.
Okay, thank you, ma'am. Right, now the next set of cases are against Google. And all of us who use smartphones, if you're using Android phones, know the role that Google and its applications play on the smartphones that we use. So now Google's cases were with respect to two particular businesses of its. One was the Android, which is the operating system, and the second was with respect to Google Pay, which is the UPI payments application that Google has developed, and how its interface with the Google Play Store, which is the app store that it has, was resulting in abuse of dominance. So right now, all of these cases that we are going to talk about, majorly they're all about either abuse of dominance or vertical anti-competitive agreements. Now, Google, of course, was found to be dominant, and this is not the first time that Google was under investigation. Google has the operating system, which is an open source Android system. So there can be different versions of Android, but Google has its own version of Android, which is what we have on most of our phones. And this is something that it licenses to OEMs, the phone manufacturers, for free. Now, when this is being done, when an OEM takes the license for the Google's version of Android, it has different options. So either it can just take the operating system and that's it. But if it wants to take additional services, like some of the proprietary applications of Google, like Maps, your YouTube, Gmail, all of this, it has to do in a bundle. So you can't pick and choose as an OEM only one application. You have to take the entire bunch of applications or not take any. So when we get an Android phone, there's always a pre-installed Google search. There's a pre-installed Gmail or a YouTube, the maps. All of these are the proprietary apps, and they're all pre-installed on the phones. And this is because of the agreements that Google has with the OEMs. So the allegation was that because of this bundling of services that Google is doing, nobody else in the market is able to access the OEMs. The OEMs don't have the choice to deal with other people. Let's say if somebody is developing a maps application, the agreement between Google and the OEM prevents the OEM from using this third-party maps application. And if they do, then they have to forego the entire suite of other applications also that Google offers. So this is creating entry barriers, and it is diminishing competition and choice for customers. Now, the CCI looked at different relevant markets because these are all different products. And the different relevant markets that the CCI analyzed in this case were, first of all, the market for licensable OS for smart mobile devices. Then there was the App Store for Android OS, because the App Store is again a proprietary Google application, and any app developer who wants to make an app for the Android version of Google has to list its app on this particular Play Store. And this is another example of how network effects plays out in digital markets, is that if somebody is installing in its mobile phone the Android version made by Google, then the incentive that they have is that they have already all of these apps developed. So this is going to make the telephone or the mobile handphone very interesting or very lucrative for the customers. So customers would be interested in purchasing this because they know the extent of applications which are already developed for this particular version of Android. And similarly, an app developer would have the incentive to make apps for this version because it knows the number of OEMs who use this particular operating system and the number of customers who are looking for applications. So that's, again, the network effect that plays out. The third relevant market that was defined was that of general web search services. The fourth was of non-OS specific web browsers like your Google Chrome. And lastly, the online video hosting platforms, which was YouTube. So in all of these 5 relevant markets, CCI found Google to be abusing its dominant position because of the tied-in nature of services that it was offering and the incentives that it was providing the OEMs. So now, in addition to the agreement that it had to tie and bundle, the Google also does some sort of a revenue share with the OEMs for not installing any other search application. So not just that the OEMs get this entire suite of services from Google for free, they actually make money off Google because of the revenue share that they get for only and exclusively installing Google search. Now, this is the second time that the CCI was looking into the conduct of Google. And this time, the penalty that they imposed was the maximum penalty that is conceivable under the Competition Act, which is 10% of the turnover for the previous 3 years, which amounted to 1337 crore. In addition to this, the CCI also directed Google to not bundle its services, to allow for other versions of Android to be developed, to basically allow for the OEMs to create more choice for customers. This is something which is under, of course, appeal now. So Google last week moved the NCLAT, where the penalty was stayed, but the direction by the CCI to rectify its behavior, that part of the order has not been stayed by the NCLAT. And now today itself, Google has moved to Supreme Court to get a stay, because they're saying that these are practices that we have developed over a period of over a very long period of time. And now if suddenly you're asking me to, change all of this, it is not going to be easy. And it's going to take a lot of, thinking through, basically, to stop this and to create alternatives so that, my business doesn't suffer, my customers don't suffer, the OEMs don't suffer. So therefore, they want to get a stay, but let's see how that goes. Now, similarly, Google already has been established to be a dominant party in the market for licensable mobile OS for smartphones. The other case related to the Google Play. So, of course, like I've already explained, the Android Play Store, which is the application, which is a store for downloading other applications on the Android. Now, within the App Store, there is a condition that if there is an app which requires to be paid for, then for that, and if somebody is making in-app purchases. So for app purchase and in-app purchase, the only UPI mode that is going to be available is going to be that of Google, which is Google Pay. Now, while there are other modes of payments that one can use, but the UPI mode can only be Google Pay. Now, what happens is that when somebody, an enterprise who is dominant in one market, leverages that dominance to get more market share in another line of business that it is developing or an adjacent market, then that is also considered to be abuse of dominance, and which is what happened in this case. So the CCI say that Google, you are dominant, first of all, in the market for licensable mobile phone OS. Then you are dominant in the App Store market as well, because on the entire Google, on the entire Android universe, your App Store has the maximum number of applications, and every OEM installs your App Store because you mandate it to do so in that package of proprietary applications. So now, based on this, if you are tying only your UPI payment system for making purchases and in-app purchases on that App Store, you're leveraging your existing position of dominance to gain more foothold and to attract more customers to use this other service that you have developed, which is anti-competitive. Now, interestingly, in the UPI payments system world, Google Pay is not a dominant party. In fact, it is PhonePe which has the maximum market share. So therefore, in this case, the abuse is happening in some market, but it is in a different market where the enterprise is not dominant. But it is happening because of the existing dominant position is being leveraged. So this is an interesting way of how dominant positions can be used by companies. And this is a very usual way for competition regulators across the world to see how companies are behaving. And a lot of companies have been penalized for this kind of leveraging. Now, for this particular conduct of Google, it was penalized 936 crores. And of course, it was directed to modify its conduct and remove, these restrictions and allow for alternate payment modes to be processed by app developers and on the App Store. Now, these are three cases which are recently been decided. In addition, there are multiple other investigations that are going on before the CCI in the digital market space. So one is, of course, Flipkart and Amazon. Then a similar to this Google Pay, Apple Pay is also being investigated. Google is being investigated for some other conduct as well with respect to smart TV. Now, similarly, like for the Android for mobile phones, the smart TV also comes with Android, and it comes with these bundled applications. So if you can see that, this is the Android for mobile phones is a separate market. Android for smart TV is a completely different market that is being looked at. Then Book My Show is also under investigation for exclusivity agreements. Swiggy and Zomato are also under investigation for exclusivity, for parity clauses, for preferring their own cloud kitchens over other restaurants in their listings, in their search. So these are the different kinds of conducts that are being investigated by the CCI in the digital markets, and these conducts are also being investigated in parallel for offline markets as well. Now, this is what has already happened. In the pipeline is something called the Amendment Bill for Competition Law. And in addition to several procedural changes, some other mechanisms for settlements and commitments, that enterprises can now avail, which did not exist in the current version of the Competition Act. There are certain changes which are being brought about specifically to deal with digital market companies. So for notification of deals, M&A activity, so far the threshold has always been based on assets and turnover of the companies. But now something called the deal value threshold is being introduced, which would cover basically deals in the pharmaceutical space and in the digital market space. Because a lot of times when these acquisitions happen in these markets, the size of the target company is very small, and it doesn't cross the thresholds that are being set. But at the same time, these are killer acquisitions where the smaller company could have actually posed competition to the acquirer in the long run. And these acquisitions are happening basically so that competition is removed, raised to the ground at a very early stage in the market. The other is that for determining, how a company can be dominant, typically there are different factors that CCI considers, but typically market share is a good indicator. And in addition to the market share, something called any other criteria clause is also being included, and it is our understanding that in the future, the data that a company has, the network effects that it operates on, the interoperability conditions that are there, whether they're creating closed door ecosystems or interoperable ecosystems, all of these factors will also play a part in the assessment of whether a company is dominant or not. And lastly, very recently, there has been a recommendation by the Parliamentary Standing Committee to introduce a specific legislation for competition in the digital markets. Now, this is something that is a trend happening across the world. So in the EU, last year, this has happened. In the UK, this has happened. Japan has also made certain changes in its legislation. And it seems like in India also we are heading in that direction, where we would have probably a regime which controls and checks competition in digital markets as a regulatory requirement, and not as a after the fact assessment of conduct. So if a company in the digital markets is of a particular size, then they will probably have to have some sort of requirements from a regulatory perspective to check their conduct before it becomes abusive. Now, at this point, I would like to invite Sharanya to join us again in this discussion, because this is the final set of takeaways that we have from this entire discussion.
Right. Thank you, Neelamra. I think I speak for everyone, hopefully, but it was really nice. It's a very complicated topic which you've managed to sort of squeeze within 35-40 minutes. So kudos to you for that. So I'm just going to, I think we can have a discussion amongst us, between ourselves right now, Nilambra, which is, what are your takeaways now from the Google order or the MMT order, or the fact that the relevant market has, there's been these twists and turns in understanding what the relevant market is, right? Now, we all know that who is going to be affected by competition law. Typically, as I said, horizontal agreements, unilateral conduct. In both these cases, usually in horizontal, size does not matter at all. If there is a bid rigging or there is a cartel, then it doesn't matter who is how big or how bad, right? It's just per se a violation.
All is bad.
Yeah, exactly. Unilateral conduct, of course, size matters. But, there has to be a further appreciation to see whether simpliciter that size will not lead to a bad conduct. Is that, intermixed with actually a bad conduct or not, or a prohibited or a offensive conduct, right?
Right.
Now, what do you mean, Nilambra, when you say look for an inflection point? Because this is something that I know we both have discussed, especially looking at, smaller companies today. Especially, we know that Karnataka is a hub for, startups. So can you explain why this becomes, this fourth bullet becomes important, of evolving market looking for an inflection point?
Right. So basically what happens typically when, we are engaging with clients on competition law, there's a lot of resistance, for companies who think they're of a certain size or they belong to a certain market, from, engaging in self-assessment, in, looking inwards and seeing, what is their conduct like, what are their agreements like, who are they dealing with, how are they dealing with their customers, their distributors, suppliers. And this is because of their own assessment of where they stand in the market. Now, in the digital market, especially for startups, especially, there is the trajectory of growth is very quick. So, today you may be a small company. In 3 to 4 years, you may become, a market leader in a particular space. So, for anybody who is, so somebody like, let's say, an Uber, when they came to India, they were a very small company. They had a lot of competition from, your typical, call a cab services, Meru and everybody. And the period in which, the tide turned for Uber and Uber became the norm, or became the dominant, or, the enterprise with, significant market power, was very short. Now, if companies don't take care of their conduct, or at least are not, they don't appreciate, what kind of conduct is okay, till a certain point, and when that becomes anti-competitive, if this realization is not something that you begin your journey with, then once that point where you become, a company with significant market power that comes, you don't realize that, now maybe I need to probably change my practices, or I need to decide, which way I want to, do I want to just, hedge my risks, or do I want to be more on the side, or, err on the side of compliance. So that is why it is very important to look for this.
Yeah. So just taking that forward from what Nilambra just said, is that there are industry practices, right? Number one, there are industry practices. But, so for example, exclusivity agreements. We know that many industries have exclusivity agreements, right? Price parity is also an industry practice, actually, in the industry that MMT operates. These are, you consider them to be the norm. Nobody really gives additional or extra thought to these things. But what is happening is, today the CCI is looking at independent, non-offensive industry practices, putting them all together. Why are they putting it together? For 2-3 reasons. They're putting it together because you have reached, or that business has reached a particular threshold or inflection point, as she said, because of which it is possible that a combination of these traditional practices, um, industry practices could lead to either exclusion of people from business. You could be creating entry barriers. You could be leveraging yourself from one market to another market, which we saw in the Google Pay case, where they wanted to attract people into the Google Pay world, right? And so these are, so therefore, when people come to us, when clients come to us and say, you know what, we all have exclusivity clauses, but how are you going to word that exclusivity clause is very, very, very important. Similarly, I know that there's a question on parity clauses, there's a question on IP, right? These are all technically anti-competitive. Actually, they're technically, in absolute terms, you can call them anti-competitive. Why does it not come under the radar? Because for a certain threshold, it doesn't have any impact on the market. So see, competition law doesn't say don't do anything that is anti-competitive unless it is at a horizontal bid rigging. It says don't do anything which is going to impact the market, which is going to adversely impact your competition, right? So that is really where one has to constantly see. So when clients come, we say, listen, and when we do their, contract audits, or when we, specific clauses are brought to us. So you have non-compete clauses, you have exclusivity clauses, you have parity clauses. These are very typical clauses that we see. So then we say that you can't look at these clauses in isolation. Try to understand how big or how strong a position you hold in your market, number one. Number two, how have you defined your market in your public documentation, internal documentation? Today, everybody wants to be very unique, right? Everyone is saying, I am niche, I am only catering, I am so special, my service is so special, my product is so specialized. Unfortunately, while you do that for your investor pitches, while you do that to attract customers, because everybody is bored of the mundane, you need to attract and have that USP. That also has the impact of narrowing down your market. And the narrower the market, there's a inverse proportionality. Narrower the market, higher the chance that you are going to be dominant in that, or at least having a significant market power in that market. So these are very important. So whenever we look at these clauses, non-compete, exclusivity, parity, any other slightly restrictive clauses, it has to be seen in light of who are you, where are you today in your market, who are your competitors, how are you positioning yourself before the authorities? Do you have an interlinked distribution system? How are you dealing with your dealer and distributor network? Are there any flowbacks that are happening? Are you integrated vertically, either with your vendors or with your customers or dealers? These all become very, very relevant, even when you are going to examine smaller things like one or two clauses in a contract. Nilamra, do you want to add anything to some of the other things like self-referencing, etc.?
No, I think you've summed it up, very accurately, Sharanya. I think these are all the things that, one needs to go back and reflect on, as businesses, and this is something that is true, for both digital as well as offline businesses. So the same issues arise, in the context of offline businesses also.
Absolutely. I think what you said is very relevant, which is that we must understand why there are few peculiarities with the digital space. Those are all, at the end of the day, you will see reflections of that in the offline space. It is just that it takes many years to reach that point. You can avoid scrutiny because offline is difficult to sort of assess. Unless there is actually a complaint or an information that is filed, it does become difficult to understand. People will have different types of distribution network. People will have different types of shares in the market. Digital footprints are much easier to catch. But
track and catch.
if these get reflected in your offline brick and mortar businesses, that's where you need to worry about.
Absolutely.
Great. I think we can conclude our competition panel. And I'd just like to hand it over to BCIC to introduce and start with the second panel.
I think Prashant can start now. Been introduced.
Yeah,
Great.
go ahead.
Lovely. Thank you.
So Prashant, you can go ahead.
Hi, Prashant. You're on mute, Prashant.
Unmute, yeah.
Hi, Sharanya. Good evening, everyone. Sharanya, would you like to start with a brief introduction?
Yes, let me just set the tone. Thank you, Prashant. Right. So now we quickly move over to our second session. This is the new Digital Personal Data Protection Bill that has come in late last year, sometime in November. It was released. Again, I always start every seminar on digital on data protection. I always say we are lawyers. Prashant and I are lawyers, and lawyers usually look for loopholes. Lawyers usually try to see what is that one loophole or few loopholes in any legislation that legitimately one can take advantage of. That's unfortunately how lawyers thrive. We are very tempted to do that with the Digital Data Protection Bill also, of course. And I can tell you there are not one, there are several ambiguities. I don't want to say loopholes, several ambiguities in the law that has been laid down. But let us first step back a little and understand today the Digital Data Protection Bill in the form that it has been issued and released deals with privacy. It deals with data that belongs to you and me. It belongs to everybody who's on this group today, right? Our personal data, our telephone numbers, our email ID, our financial transactions, our health information, our sexual preference, all of this, our transactions, e-commerce transactions, the kind of food we order, all of this is digital information and digital data, right? Some of it can be used to trace back the identity of the individual, and that is really what is covered under the Data Protection Bill. But at the end of the day, we must understand that we must keep any law that deals with safeguarding an individual's rights. We must always try to say that we must respect the law, we must implement the law in the way and for the reason for which it was enacted. So as businesses, we all want to use as much digital data that is available. We use it for several things. Just as Nilambara just said, you use that information to enter new markets. You use that information to get more information about the market, about your customers, your footfall. You can develop new products. You can do targeted advertising. All of that is happening today because of the swath of data that companies are possessing. It is this kind of data which deals with individuals that is sought to be protected. So we must try to honor and try to always interpret it in a manner that an individual's privacy is always protected, because in 2017 and 2018, the Supreme Court of India has held that fundamental right to privacy exists. All of us today have a fundamental right to privacy. Even if there is no legislation today, I can go to any court and say that this violates your judgment of Puttaswamy, that I can do that. So it's good that they're trying to bring in a legislation. The only problem is that this legislation, every few years, they are releasing a new version of the draft. Prashant and I worked extensively on the 2019 version, which was a very, very comprehensive version. It was in line with the European standards, which is called GDPR. It was stricter than GDPR. It's something for us to be proud of. Though industry did push back, we pushed back the previous time in 2019 on certain clauses which were not reasonable. which were which was against the constitution, etc. And I would say we have succeeded to an extent in getting some of those clauses struck down. Today's discussion that Prashant is going to take us through is really to explain the overview of the current bill, the 2022 bill. What are the duties of a person who's going to collect this data? Who is the data fiduciary? Companies who are identifying data, collecting data, trying to process this data. What are their roles and responsibilities? And what are the rights of people like you and me, individuals or citizens or individuals whose data has been taken and is being shared or is being processed? What rights do we have? And what is the balance between this? And he'll highlight maybe a few ambiguities, which we will do in the end to tell the businesses that these are going to be tricky points where we will need to wait for some more clarification before you can take further decisions on all that. So over to you, Prashant. I hope I have set the tone for today's presentation.
Thank you very much, Sharanya. We really appreciate that. And in fact, you had rightly mentioned that the tone and tenure of the thought process that goes behind in protecting such a fundamental right has to be given due, I would say, credence, because that will be also the basis to decide any disputes that go forward. Loopholes alone will not be sufficient to save businesses from non-compliances. The true spirit of upholding the principles of privacy would in fact be adhered to while deciding any disputes. Moving forward with respect to the current topic at hand, we'll just briefly touch upon a very quick snapshot in terms of what has been the journey so far, and Sharanya had in fact touched upon that. So it all started with the Supreme Court's decision on the in the Aadhaar judgment, the first part of it, wherein they had in fact recognized the right to informational privacy, and that is where all the concepts around data privacy have in fact taken root from. Then subsequent to the decision, subsequent to the judgment, we had the Justice Sri Krishna committee that was constituted and which was responsible for releasing the first draft of a data privacy law for India. Subsequent to that, there was another bill which was introduced in 2019, which underwent slight revisions in 2021. And then subsequently after that in 2022, we have the latest version of the bill. The bill is a far cry in terms of the extensive nature or the obligations, as Sharanya had mentioned, from what it was as compared to the previous bill. It is definitely much more manageable as compared to the previous bill in terms of the obligations that were specified in the previous bill vis-a-vis the current bill. And going forward, we strongly feel that a large part of the implementation framework, which is right now quite discernibly absent from the current bill, may in fact be included as part of the supporting rules. So we'll have to see that how the current bill also gets supplemented with other supporting rules that may perhaps get released in the coming future. The objective of the Indian data protection law, as similar to any data protection law, is it is intended to provide the right to privacy of individuals. And this right to privacy is focused more around informational privacy. That is where data privacy as a concept emanates from. So it is intended to protect the right of privacy, informational privacy of individuals. And it also ensures that the personal data of such individuals is used appropriately by organizations. So one of the most common misconceptions that people may actually have is that data protection law prevents use of personal data. That is not the case. It in fact encourages the use of personal data, provided certain checks and balances are actually kept in place. And these checks and balances are in fact responsible for providing a balance between the privacy rights which the individuals may actually exercise over their personal data, vis-a-vis also how businesses may conduct their operations using the processing or by relying on the processing of personal data. So that is what the focus of the Indian data protection law also is, that it introduces a system of checks and balances, which ensures that the individuals with whom the personal data actually relates to have the necessary mechanisms in place to exercise their rights. We'll just discuss as to how they can exercise these rights. And at the same time, it also provides a certain elbow room, certain freedoms to the businesses to use that personal data. Naturally, the use of such personal data cannot be unfettered, and we'll just touch upon those points as we move further in this presentation. The current bill also provides high penalties up to the tune of about 500 crores. We'll also touch upon this aspect. And one good thing with respect to the penalty part of it, that the bill as such provides a high degree, I would say, of priority to security. So in cases where security is not in place by organizations who are in fact processing personal data, the fines is actually the maximum for such kind of lapses or lack of or not meeting the obligations as defined in the bill. So in terms of its changes, the previous bill also provided certain provisions which may in fact land up personnel into prison. So but the provisions relating to the imprisonment have actually been removed, and the current bill but the current bill as such only focuses on financial penalties. The bill also does away with the categorization of personal data. In the previous version, just to provide a quick recap, the previous bill actually had three categories of personal data. One was normal personal data, and then we had sensitive and then critical personal data. So sensitive personal data was such personal data which in fact had a very sensitive, I would say, nature to it, like financial information or such similar type of health data. All these types of data were in fact clubbed under the category of sensitive personal data. And strangely, the term critical personal data was not defined, but all these categorizations have been done away with. Now there is only one single level of personal data which has been prescribed, and the obligations with respect to the processing of such information have been prescribed under the bill. The bill, similar to the current bill, similar to the previous bill, also retains the categorization of data fiduciaries. That means normal data fiduciaries and significant data fiduciaries. Significant data fiduciaries, as we'll discuss in detail, are a different category of data fiduciaries who may have the processing by whom may actually have a significant impact on the rights or interests of the individual. So we'll just touch upon that as well. Data localization requirements have been removed or at least been filtered down or watered down. And but by and large, although it appears to be a relaxation, however, there are certain issues that we will also touch upon in our subsequent slides. Now, coming to the core part of it, when we're looking at the bill defines situations or the types of personal data to which it actually applies to. And first off, it clearly specifies that it will be applied to digital personal data that is processed within India. So it clearly demarcates a distinction between non-digital personal data and digital personal data, and applies the provisions or seeks to apply the provisions of this bill only to digital personal data. In instances wherein offline data is digitized, the provisions of the current bill would also apply to such digitized data. So the key takeaway from the applicability in terms of the current bill is that it seeks to obligate businesses or organizations only with respect to the processing of digital personal data. It is also applicable to the processing of personal data outside India if such personal data is collected in connection with profiling of data principles in India. That means if the personal data relates to data principles, it has been collected, but it is in fact being processed outside India in order to create certain profiles. A profile, as we'll discuss also later, just amounts to basically a characterization or of certain attributes of a data principle. That is what profiling generally is considered to be. So in instances wherein the data, even though it is collected in India but being processed outside India, then in such instances, the Act will also apply if there is profiling actually involved of the data principles. Another instance wherein the data collected in India but is being processed outside India would also be applicable is wherein the goods or the services by the entity who's collecting or processing such data is being offered to individuals in India. So in instances where the goods or services are not being dedicatedly offered in India, but they may still be processing personal data of individuals in India, then also the bill will not apply. So for the bill to apply, in order for it or for the bill to have an extraterritorial effect, that means to have an effect for processing instances outside India, it has to be collected in connection with profiling, or it has to be in relation to the offering of goods and services to individuals in India. The bill specifically carves out an exception in terms of its applicability to non-automated processing of personal data. Although the term may appear to be technically incorrect, however, it focuses on manual means of collection of personal data, and it has to be read with the first line or the first applicability criteria that we had discussed before. So wherein certain processing of data is in fact digital in nature, even though it may be done by non-automated means, not necessarily manual, but non-automated means, it would still be covered. But as such, the bill sort of specifies that non-automated processing of personal data would be excluded from the scope of this bill. Offline personal data would in fact also be excluded. That means data which has not yet been digitized. Personal data that is processed by an individual is also excluded, provided the same is actually done for processing for any personal or domestic purposes. So you storing the name and phone number of your family members, even though it amounts to processing, it would be outside the purview because of this exception. And lastly, the bill also provides that personal data that has been in existence for at least 100 years would not be covered, or the processing of such information would not be covered under the current bill. A quick snapshot of the changes, some of the notable changes, we'll just discuss them very quickly before moving on to the core features of the current bill. The subcategorization of personal data, as what we discussed before very briefly, have been done away with, so that now there are no criteria like sensitive personal data or critical personal data anymore in the bill. The requirement with respect to data portability has been removed. People who may be familiar with GDPR would know that data portability is meant to reduce the amount of personal data that can be requested from a certain individual. Like, for example, if you would want to change your mobile phone subscriber from Airtel to Vodafone, data portability would have enabled the new service provider to actually obtain your personal data from your previous service provider. But that requirement has actually been done away with. So now there is no compulsion or no obligation with respect to data portability under the current bill. The notice requirements have been simplified, and overall, the compliance obligations, particularly for the notice requirements, are much more manageable as compared to what they were previously. So in the previous bill, there was a long list of criteria that had to be satisfied in order by the notice or the privacy policies of organizations, and it was I would say quite an arduous task because it required a lot of information to be provided. Introduction of deemed consent. This is in fact one of the more remarkable inclusions, wherein in the previous bill or even generally, consent has to be specifically obtained. But India has gone ahead and also introduced the concept of deemed consent in order to reduce the consent fatigue that may actually be experienced by users who are constantly bombarded with consent forms. But again, even though it may appear to have a very broad scope of application, it has to be viewed narrowly. Considering the introductory comment that Ms. Sharanya had in fact provided, that we are to look at it not from a point of it being a loophole, but in terms of what needs to be done in order to protect the interests of the individuals involved. The right to be forgotten has been removed. So essentially, individuals have various rights under information privacy, and one of the rights that were in fact present, the right to be forgotten, has now been removed. Data localization has been removed. So no longer you are required to keep a copy of the personal data here in India. It can all be in fact stored outside India. The cross-border data transfer requirements have been simplified, but although it may appear that the provision has become very simple, in the sense it's only 2 or 3 lines as opposed to about 50 lines previously. So it sort of reduces various other conditions, but as such, even though it may appear to have been simplified, there are certain issues which we will just discuss. And the penalties have been capped at 500 crores, and non-personal data has been removed from the ambit of the bill. Please let me know in case if you have any questions. I'll be happy to answer them even in between, or we can just keep them till the end of the presentation. Even though we have a few definitions to go through, but I'll just touch upon the definition of personal data and processing, because that is what defines the scope or that are these two terminologies, I would say, are defining the scope of the legislation to a great extent. So what exactly is personal data? The personal data means data about an individual who is identifiable by or in relation to such data. Now, the keyword here is that we need to see that there is data actually involved. The data has to be about an individual, and this individual is a natural person, not a corporate entity, not a juridical entity, but a natural person, and who is identifiable. Previously, the terminology identifiable was further supplemented or characterized by directly or indirectly. Even though now it is absent, it does not necessarily mean that identifiable refers only to directly identifiable. So even in instances wherein certain data about an individual indirectly is capable of identifying or establishing the identity of said individual, such data would also be considered as personal data. So just to give you an example, data which directly identifies you are your name, your Aadhaar card number, or your PAN card number, your telephone, and data which is indirectly identifiable by you is perhaps the device identifier of your mobile phone coupled with the location. So such information combined with other data sets can in fact establish the identity, and such data sets are also included within the scope of personal data. Now coming to processing, as you will see that processing in relation to personal data means all these different operations. It sort of starts with collecting and goes through a series of other processing which are included within its scope. So you'll see collection, recording, organization, storage, etc. are all included. Even till the end, if you see erasure or destruction is included within the scope of processing. So all these activities, basically anything that you do in relation to data, even if you access it or touch it just to see what it is, it would amount to processing. So all these different processes or computational, I would say, computer implemented aspects in relation to data do amount to processing. So the processing has been used in a very broad connotation. It is not just simply analytical processing of data based on certain rules, but any one of these activities in relation to personal data would amount to processing. So data fiduciaries and data principals are another two, I would say, the primary actors of this legislation. So data fiduciary is any entity. It could be an individual. It could even, in fact, it includes also the government. It is any entity which sort of determines the purpose and the means for processing of personal data. So any entity which decides that how the data is supposed to be processed and what is the personal data that is supposed to be processed would automatically be considered as a data fiduciary. And then we have the data principal, which is basically the natural person with whom the personal data relates to. We'll just skip over these parts because significant data fiduciaries is also covered in the later slides. But in case if there are any specific questions, we can address them later as well. So the outline of the bill is that it provides a series of obligations for data fiduciaries. That means, as what we had seen, data fiduciaries are entities which are responsible or which determine how the personal data is supposed to be processed. So if you recall, in the initial parts of our presentation, we had touched upon this point that the privacy legislation as such provides a balancing act. It sort of tries to strike a balance between the rights and the privacy rights of an individual, as well as the interests of the organizations who are using that personal data. And that is what such obligations actually enable. Such obligations for the data fiduciaries actually enable that balance. So the data fiduciaries would be free to use or to process the personal data, provided that they adhere to the obligations or to the requirements of the bill. Secondly, the bill also outlines certain rights and duties of the data principal. So right to information about the personal data is the first and foremost rights. That means as an individual, for example, each one of you have the right to actually approach an entity and check and retrieve and determine whether they are in fact processing personal data in relation to you. And if that is the case, then you also have the right to request for a copy of that personal information, just to basically assess whether that information is in fact correct or not. Connected to this right of information is the right to correct an erasure. So in instances wherein the information captured is incorrect, that the error could have happened, not necessarily deliberately, but it could have actually been introduced as a matter of error itself. But the privacy legislation also provides the individuals the right to correct such an error. And in cases wherein such an error cannot be corrected, then the erasure of that record itself could in fact be sought by the individual. The other right which the bill actually provides for is a right of grievance redressal, that now under the bill, the data principals, that means the individuals, have the right to approach the data fiduciaries, that means the organizations or entities processing the personal data, in case if they have any grievances with respect to the nature of the processing being undertaken. And fourthly, we have also now a new kind of a right, that means right to nominate. So in instances wherein an individual or a data principal passes away, then in such instances, their heirs could in fact exercise the right in the personal information of the deceased individual in order to I would say regulate how their data is in fact being processed. It also specifies certain specific conditions with respect to the cross-border data transfer. There are certain administrative changes in terms of prescribing the Data Protection Board, which is going to be the regulatory authority for issues pertaining to the processing of personal data. And it also now provides an alternate resolution mechanism, particularly in cases wherein certain disputes are raised by data principals against the data fiduciaries. Now coming to consent. So as I had mentioned, that data processing would in fact or is in fact allowed under the bill, provided there is a legal basis for the processing of personal data. Now, in addition to the legal basis, the legal basis can in fact established by multiple ways. One of the foremost ways by which would qualify as a legal basis is a law which is in place, which allows a certain data fiduciary to process personal data. In case wherein such a legal basis is not available, the second legal basis which is in fact available or which has been prescribed under the bill is consent. So this consent is just basically an affirmative action with respect to the nature of processing, which is intended for the personal data that I as an individual actually provide. What does this actually mean? That, for example, an entity or a hotel wants to reserve a table, then in such instances, they may ask for my mobile phone number. And in such instances, I would in fact agree. They would in fact, first of all, communicate that for what purposes they would in fact use the mobile phone number. And I would in fact provide a clear and affirmative, conveyance of that, okay, you are free to process or use my mobile phone for the specified purpose. So consent is one of the foremost bases or one of the important bases which is used or which has to be obtained in order to process personal data. Consent can in fact be withdrawn or also managed. So initially you may have given consent for 3 types of processing, but at a later stage, you have the choice, you have the right to withdraw consent for 2 of those processing activities or withdraw your consent completely or absolutely. The performance of the contract cannot be conditional on consent. This means that a service provider cannot, deny providing a certain service just because you fail to provide certain aspects of the personal data or consent for processing personal data. Certain types of personal data would in fact be required. But like, for example, for a mobile phone connection or for buying a movie ticket, the movie hall should not actually ask for the names of my spouse or my parents, because that as such is not something which is required for said purposes. But performance of that contract cannot be conditional on consent. Consent has to be verifiable, and that onus is on the data fiduciary. The reason why it is verifiable or it has to be verifiable is so that at a later stage, whenever a dispute actually arises with respect to consent, either the data principal wants to withdraw or further manage the consent, then in such instances, that consent has to be revisited again. And to such an extent, it has to be verifiable to determine what exactly was the scope of the consent previously and how it needs to be managed by the data principal, considering a certain circumstances or a certain scenario. As what we had discussed, deemed consent has been introduced. Now, with respect to consent, as what we had discussed, that it has to be specifically obtained. That means the consent, a certain, information describing the purpose for which the personal data is going to be used is provided to the data principal or the individual by the organization. And in response to that, the consent is actually provided. Now, the principle of deemed consent sort of obviates the need for the organization to provide the purpose upfront. So in instances wherein, because of the nature of the transaction, which is in fact contemplated, there is a reasonable expectation by a data principal that, okay, personal data has to be provided, no consent is actually required. So the plus side of this is that previously, for each and every processing of personal data, one specifically would have to obtain consent. That typically is done by way of a consent form, and that generally, if you are aware of GDPR, usually forms one of the first things that you encounter if you are accessing any digital platform. They will ask for your consent. So it has been observed that requesting for consent for so many things, particularly in the context of what needs to be provided in as a digital service, results into a phenomenon referred to as the consent fatigue, wherein the data principal may just, for the sake of accessing that service, may just tick each and every checkbox without specifically reading what exactly is the nature of processing that is for which the personal data is going to be used. But that is no longer the case considering the concept of deemed consent. If there is a reasonable expectation of the personal data that has to be obtained from a data principal, and that data principal voluntarily provides in response to that reasonable expectation, then the deemed consent would be sufficient for the organization to process that personal information. Although it appears to be a very broad kind of I would say, kind of a provision or an opening in the law, it is not the case. So many a times, or in certain instances, we've actually seen people saying that deemed consent is perhaps a free-for-all, which will allow the organizations to process the data in any way possible. That is not the case, because the bill clearly says that, first of all, the data has to be voluntarily provided, and this voluntary provision of data is actually in response to a reasonable expectation, particularly in the context of what is expected as a service that the data principal seeks to avail. And to that extent, in our view, deemed consent is not a free-for-all, and that has to be kept in mind. So even though deemed consent can be used in order to ease certain obligatory burdens by the organization, it should not be relied as a free-for-all or for being the basis for processing personal data in any way that is actually desired. Other areas where deemed consent may be relied is for the purposes of employment. So for the purposes of employment, obviously, an individual may be required to provide their personal information like their name, their bank account number, etc. And in such instances, certain aspects relating to employment like salary or payroll processing, attendance management, all these things require certain inputs or certain information which need to be provided by the employees. So even in such cases, a specific consent need not be obtained from the individual. In instances involving public interest, like for example, detection of fraud or network security, also no consent is actually required if your personal data is being processed. But again, the specific purpose is right now provided here. If the personal data is being processed specifically for the detection of fraud, specifically for the purposes of network security, then only deemed consent or the, I would say that the relief or relaxation under deemed consent can in fact be availed. And then further, we have fair and reasonable purposes, which have also been defined under the legislation, under the proposed legislation, the bill, as being one of the grounds under which deemed consent can in fact be used for processing of personal information. So that sort of covers in terms of what is the basis for the personal data to in fact be processed. Now we'll quickly come to the obligations of the data fiduciary. So as what we had discussed, that the data fiduciaries are those entities which exercise, sort of decisional control over the processing of personal data. What does that actually mean? That means they decide which personal data or what types of personal data have to be collected or have to be processed, how they're supposed to be processed, and which entity needs to be targeted for obtaining that personal information. So all those, all such entities are basically referred to as data fiduciaries. So one of the foremost requirements for a data fiduciary, even before they can collect any personal information, is that of notice requirement. This notice requirement is typically enabled or implemented by way of a privacy notice, what you would generally encounter while visiting a website. So the privacy notice at least on the purposes of the current bill, should meet certain minimum criteria which have been specified under the bill. What are those criteria? First of all, the notice has to be itemized and in clear and plain language. It can be made available in English or any one of the languages which have been specified under the 8th schedule, so Hindi or other regional languages which are prevalent in India can in fact be utilized for providing that the privacy notice. The notice must specify the description of the personal data to be collected. So in cases where I'm collecting name, telephone number, and address, I need to specifically indicate that these are the 3 personal data types that I'm actually collecting. If you're collecting some more data, then those also have to be listed out. To the extent possible, or we would in fact suggest that to the extent possible, you have to be very true to the in order to you have to be specific with respect to what data types you're actually using, and those have to be reflected in the privacy notice. Any deviation from what you're actually collecting versus what has been specified in the privacy notice would be construed as a violation. So in case if you have a doubt that, okay, I perhaps may collect or may not collect, it is best to include that data type upfront in the privacy notice, and that would more or less take care of any other compliance issue, particularly with respect to the privacy notice. In addition to the description of the personal data, the purpose of processing also has to be specified. So whatever is the purpose for which you are processing that personal data has to be specifically spelled out in the notice requirements. The details of the data protection officer or the appropriate officer of the organization have to be provided here as well, particularly for the purposes of grievance redressal. So that person or that point of contact would become the I would say the personnel who would be approached by data principals in case if there is any grievance that they may actually have, or in cases where there is any dispute that's actually involved. In instances wherein personal data has been collected previously, the notice requirement should be refreshed or should be updated as soon as possible. So obviously if the bill is assumed to come into effect today, then obviously there are a lot of businesses who already have a lot of personal data with them. They are already processing the personal data to a large extent. To this end, the bill requires that as soon as possible, the notice should in fact be refreshed, should in fact be prepared in order to reflect the manner in which the personal data is being processed. One thing that we wish to in fact indicate here that it only specifies as soon as possible. However, the quantum or the time period within which the notice is supposed to be generally should be prepared as per the processing has not been prescribed. We believe that this aspect or this timeline would in fact be communicated in the rules once the same are in fact published or are in fact put for public consultation. Further, data fiduciary obligations require that the data fiduciaries ensure that all the personal data is accurate and complete. They should also implement appropriate technical and certain organizational measures to ensure that data is in fact is maintained as confidential, that the privacy with respect to the data is in fact respected. Examples of such technical or organizational measures, include role-based usernames and passwords, which allow certain individuals to access certain personal data and not everybody to access all the personal data that may be there or that may be available with the organization. Implement security safeguards to prevent breaches. That means any unauthorized access should be preventable by virtue of the security mechanisms that may be implemented by the organizations. And also implement appropriate breach reporting procedures. So one thing that also has to be kept in mind is that just because a breach has actually occurred, that does not necessarily mean that the organization is in violation of the provisions of this bill. Breaches can happen even despite the best efforts that the organizations may in fact may have in fact made with respect to security. But what is considered to be a violation of the bill would be if you fail to report this breach. So an appropriate breach reporting mechanism has to be implemented or has to be put in place by the organization so that whenever the breach actually does happen, the appropriate reporting procedures are in fact followed, so that the nature of the breach can in fact be reported either to the individuals or to the authority, depending upon the nature of the breach itself. The specifics of this breach reporting provisions are right now not specified. It is very much possible that those will also be included in the supporting rules, which may come at a later date. Implement a grievance redressal mechanism. So in cases there is a complaint in terms of how the personal data is being processed, or whether the personal data being processed is incorrect, such kind of a grievance redressal mechanism can be relied by the individuals in order to address the issue at hand. Obviously, take appropriate consent for transfers. Typically, when we are looking at personal data, which is in the digital form, it may be routinely transferred between organizations. I'm not saying that the organization may be selling the data, but even for the purposes of storing the data in a safe and a secure manner, third-party services could in fact be relied on, like cloud services, etc. So in cases wherein such data has to be transferred to such a third-party platform, an appropriate consent has to be taken upfront or before such transfers can in fact be implemented. So that is something that needs to be kept in mind, that whatever you do with respect to that data, appropriate information should be conveyed to the individual in advance, so that the consent for the same can in fact be obtained. Ensure that data sharing or data transfer is pursuant to a contract. So whenever you have the example that we've just referred to, wherein cloud services or cloud platforms are used for the purposes of storing data, then such kind of an engagement should necessarily be implemented under a contract. That is what the bills actually requires from data fiduciaries. Any engagement with data processors are just basically entities which process the data based on the instructions of a data fiduciary. They don't exercise any control, or they do not decide how the data is supposed to be processed. They only process it based on what the data fiduciary tells it to do. So in such instances, any engagement with the processor also has to be done under a valid contract. In instances wherein the personal data is involving that of children, verifiable parental consent has to be obtained as well. And under no circumstances can children data be used for the purposes of profiling. There's an absolute bar on the profiling of children. Separate obligations for significant data fiduciaries, and significant data fiduciaries are just basically a class of data fiduciaries who are classified as significant data fiduciaries based on a number of factors. For example, volume or the sensitivity of personal data or the risk of harm, and other factors that as may be specified even at a later stage. So social media platforms who have a large volume of personal data available with them are most likely to be considered, or are most likely to be classified as significant data fiduciaries. For such data fiduciaries, additional obligations have also been provided. That means they're necessarily required to obtain a data protection officer who is responsible to the board. So a very high ranking officer would in fact have to be appointed as a data protection officer. In addition to a DPO, they are also required to appoint an independent data auditor. The specifics of the data auditor or the qualifications of the DPO have right now not been prescribed, although they may be defined at a later stage in the accompanying rules that may be released later on. And in addition to the appointment of these two officers, they are also required to periodically undertake various assessments referred to as a data protection impact assessments, audits, etc., in order to ensure that the processing of personal data is up to the privacy standards which the bill actually requires. So these are the additional, I would say, obligations of significant data fiduciaries. So as what we discussed, that generally now with the within a digital framework or within a digital environment, it has become very easy to conduct business, to share data, and many a times the sharing of data could in fact happen across borders. For example, you have a multinational corporation wherein the headquarters are based outside India, and you have an Indian subsidiary or the Indian counterpart based in India. In such instances, it is quite possible that periodically the employee data, the Indian employee data, is being shared with the headquarters. And it could be just because for the purposes of determining various aspects in relation to the Indian subsidiary. Now, obviously, this amounts to a cross-border flow of personal data. And previously, there were a lot of conditions or restrictions in terms of what type of data can in fact be shared. But those restrictions have been relaxed. and generally as such cross-border transfer of personal data has been permitted. So previously there was also a requirement that sensitive personal data has to be kept here in India as well. You can transport it, you can share it across or to an entity outside India, but you have to necessarily retain a copy of the same here in India. But right now that relaxation, that requirement has been completely done away with. And as such, it appears that cross-border transfer of personal data is generally permitted. However, the permissibility of such a transfer is dependent on the government notifying the countries or the territories to which such a transfer may in fact be permitted. There is no additional criteria that has been specified under the bill, which can in fact be looked into to assess that what jurisdictions would in fact qualify or would in fact be considered as permitted to such for such data transfers to in fact take place. So to such an extent, there is only one requirement, and that is the only requirement which either would have to be adhered to if cross-border flow of personal data is in fact contemplated. But if that requirement is not met, there are no fallback conditions or criteria that may be relied for enabling such a cross-border flow. So even though it has become very simple, it is quite possible that this may impede a lot of data transfers, particularly if most or some of the more prominent countries are not notified by the government as being safe or as being notified as allowed or as allowable for the purposes of cross-border data transfer. With respect to the other provisions, we have certain administrative changes also, wherein the Data Protection Board is going to be formed under the bill. And the Data Protection Board is going to be appointed by the central government, and it will have various powers to basically ensure that compliance with respect to the privacy principles as outlined under the bill are in fact met by the organizations. In addition to this, we also have various provisions for alternate dispute resolutions, wherein the DPB itself, the Data Protection Board, can in fact seek resolution between the data principal and the data fiduciaries through mediations or through other such alternate modes. The DPB is now also empowered to actually obtain certain undertakings, particularly in the context of specific actions, say by a data fiduciary that they will, undertake to do X, Y, Z in order to in relation to the processing of personal data, and that is something which is also permitted by the DPB. This, in our opinion, is going to further reduce, I would say, the threat which the previous bill in fact sort of imposed, that in cases of non-compliances, the only consequence was either penalty or perhaps imprisonment in case if the contraventions were very severe. But now that is no longer the case. In cases wherein there is a deviation, these data fiduciaries can in fact submit an undertaking before the DPB and obviously then work towards removing that deviation in order to become compliant with the provisions of the bill. So we've already discussed this aspect, that there are a number of penalty amounts that have been provided, the most being prescribed for security safeguards not being in place, which is around 250 crores. And then any other defaults generally can also invite a further penalty of up to 50 crores if there is any indication of non-compliance. So this is not the only penalty that has been provided for data fiduciaries. Even in cases wherein the data principals, initiate frivolous proceedings under the garb of enforcing their rights in the privacy rights in the information. In such instances, the data principals can also be fined up to rupees 10,000. So in our view, it has sort of become balanced, wherein certain frivolous actions by the data principals will also be discouraged to a large extent. So that sort of squares up. I know that I'm sort of crossing the time limit, so I'll just take a step here. But there are certain challenges which, like consent has to be refreshed. You need to have various technical measures in place, etc., etc. And all these things necessarily have to be looked into in order to ensure that there is compliance with the principles of data privacy as outlined in the bill. So I apologize for slightly rushing towards the second half of the presentation because of the paucity of time, but we'll be more than happy to take up any questions. Sharanya, do you have any closing remarks on this?
No, I think very, very relevant. And I think let's wait for questions. Again, as you're saying that some of these are things that people have to look inwards and see how much they can comply with. So compliance obligations are going to be there. But I think let's wait and see if there are any questions.
There are questions in the chat box.
Oh, just give me a moment, please. I'll just.
I can read. How does the latest standing committee report on digitization affect CCI's decision-making process?
Read out the name.
Sharanya,
Also.
shall I take that?
Yes, please, Neelam. Yeah.
Right. So the report is basically proposing an ex ante sort of framework, which will include certain compliance requirements and certain conduct requirements on the part of digital companies of a particular size, typically. So let's say somebody who is dominant, like Google, would probably have to ensure that it is not engaging in self-referencing. So a lot of these are measures to basically ensure that there is no falling foul of the Competition Act. But having said that, if there are any violations, the competition law ex post as it applies will continue to apply. There are also going to be penalties for ex ante violations now. So if the different kind of compliances that are going to be built into, I mean, of course, we are only just speculating how this will function. Because there's no bill right now. This is only a standing committee report. So if taking a cue from how this has been done in the EU, if that is how we in India also propose to do it, then there are going to be penalties for violation of those compliance requirements as well. So there'll be like it's basically going to be, like a double whammy on large digital companies. I think there's one more that I saw here on grant of IP and in the context of CCI. So yes, I mean, not all IP related agreements are exempt from CCI scrutiny. There is an exemption for certain kind of clauses in agreements which are necessary for utilizing one's IP rights. But then, of course, IP rights are directly in conflict with competition law because they create monopolies. So there is nothing which sort of safeguards IP rights against actions under competition law.
Can parity clauses be brought under the purview of resale price maintenance?
So that will depend on how the clause is structured. It'll have to be a case by case assessment. But parity clauses typically wouldn't amount to resale price maintenance. But it'll have to be seen. It's not a straight jacket answer to that. The next question is the same as the one before on the standing committee. Yeah. Yes. So I think that's all the questions for competition law.
Is there any delineation on consumer right to service after exercising right to any personal data?
So yes, so as I had mentioned, and I think so, the gentleman who had posed this question also found the question answered. But there may be instances wherein the personal data necessarily has to be provided in order for the availing of the service under consideration. So above and beyond that, if there is the bill as such specifically provides that access to a service just cannot be denied if you do not give consent for the processing of such additional information. So that is what the focus of that requirement is, that to the extent that your personal data is in fact required for the provisioning of a certain service, only for that you have to provide consent. Under such circumstances, if you do not provide consent, the service provider is in fact free to deny the provisioning of that service. So, but yes, over and above that minimal level of personal data, one cannot, subject the provisioning of service based on that additional personal data.
Thank you. Actually, there is a statement and challenges is sought. It should be no surprise that roughly 70% of respondents in a new Avant Analytics study say that fear that a successful security breach could cost them their job. Fortunately, data professionals are learning new tricks, and available technology, often infused with AI, is getting better. So can you throw light on such challenges?
So, as I had mentioned, that typically a breach can in fact occur despite the best efforts of an organization, despite the best security measures, a breach can still happen. And in most of the circumstances, I read a statistic somewhere that in most of the circumstances, the breach actually happens because of a certain careless act by a person within the organization. So many a times a computer is left on, or you click on a certain file which is not supposed to be clicked. Things like that may actually result in the breach. So such instances are in fact now being countered by technological measures which rely on AI, and those are in fact have been found to be more effective, particularly in the context of how to regulate the network operations within an organization. So by and large, yes, AI would I would say, would be relied on a tool, particularly in the context of ensuring that various security aspects of an organization are adhered to the best possible way. Not everything can be codified into a rule. So that I strongly believe that AI is going to be one of the more prominent tools, one of the more effective tools for the purposes of network as well as confidentiality security, security of information.
So is there any other questions? One question I have is unfair trade practices. You have the Consumer Protection Act also deals with it. Competition law also deals with it. What do you think about this? How do the consumer go there? I know B2B is more of into competition law, but the unfair trade practice is also under the Protection Act, Consumer Protection Act.
Right. So the objectives of the two legislations are completely different. The Consumer Protection Act is there to redress a harm that has happened to a particular consumer or a particular group of consumers sometimes. However, competition law is not, the effect could be some benefits to consumer under competition law, but the objective is to regulate market forces and to ensure that the market forces are not being meddled with by a particular player or a group of players in the market, so that in the long run, competition in the market is sustained, and it is only the natural forces of demand and supply which determine which companies stay in the market. The efficiencies of those companies determine whether they become market leaders or they're at the bottom of the table. The forces of demand and supply determine the costing of products, and so on and so forth. So the objectives and the means of achieving those objectives under the two legislations are very different. Definitely there is at the end of the day, both aim at benefiting consumers, but consumer protection has a very narrow and limited scope and also objective, whereas competition law is much wider, and any investigation, any decision under competition law is not going to give any personal benefit to an individual. It is only going to rectify market practices. So let's say if today you've suffered at the cost of a competitor or at the cost of a service provider, if this enterprise is, let's say, a dominant enterprise, and you want to claim some damages, the immediate effect is not going to be any relief to you. What the CCI is going to do. There is a provision for follow-on damages to entities as well, but that is not the primary objective of competition law. Does that answer your question, sir?
Yeah, thank you. Yeah. I think we have come to the conclusion, and it's time for me to thank our note of thanks.
Just one question.
Yeah.
If there is time, may I ask one question?
Please go ahead.
Yeah, this is with regard to this data protection bill and etc. Now you see, recently we had this situation of data being stolen from All India Institute of Medical Sciences, And then there was also news about blackmail and things like that. How would this new data protection bill address this kind of a practical issue? I mean, it's a real issue that has happened. How does this new bill take care of that?
So as such, sir, there are two aspects to it. One is data security and then is data privacy. So data privacy enables the data principal to exercise more and better control and basically expect more from the data fiduciary who are processing or who are maintaining their data. Now, that is one thing. So under the bill, there are again two requirements. One is with respect to keeping the network secure so that such kind of intrusions are prevented. They are not very easily, achievable. The second thing is that it also will penalize the data fiduciary or the organization if they did not take the necessary precautions in order which were required under the bill to safeguard the confidentiality or the privacy of the information concerned. So that is where the benefit of the bill actually would come in, that in instances wherein the breach actually happens, wherein the breach could have been avoided. Obviously, a breach may still happen even despite the best efforts of an organization. But to the extent that the breach could have been avoided by relying on the latest state-of-the-art technological measures, in such instances, the data fiduciary would in fact be held to be non-compliant with respect to their obligations under the bill. So and obviously would be open to penalties. So that threat of penalty or the amount which is actually involved is extremely harsh, particularly with respect to security not being up to the standards as what the bill actually requires. So in some instances, we believe that the bill would in fact force the organization to relook into the security procedures, to basically have their security measures in place, security protocols in place, which are complying with the latest and the best technological measures that are actually available at their disposal, so that such breaches or the instances of such breaches could in fact be minimized.
Thank you. Thank you so much.
Any other questions? I think we will conclude the session by a vote of thanks. I thank Lakshmi Kumaran and Sridharan attorneys, especially the speakers, Mrs. Charanya, Prashant, Nilambara. So it was a wonderful session, a great insight about the topic and more information and very futuristic. I would really place my appreciation on record, and we would like to have maybe a couple of months after the bill is passed or nearing the bill, we would really revisit this topic. I know this subject is little overboard of many members, so I think the awareness should be more. And I would also place my thanks to the Secretariat of BCIC, especially Rupa and Purushottam, who have been helping in this, and Mr. A. Murali for bringing this together and bringing it to the BCIC. I thank all the participants and members who have taken time and spent time, useful time rather, and upgrading themselves on the topic. It was a pleasure handling this topic and seeing all the speakers together. That's fantastic. So we will in future also connect and see what best can be done. Thank you very much.
Thank you.
Thank you.
Thank you very much.
Thank you.
Thank you. Thank you, everyone.
Thank you.
Thank you.